This is Module 5, Crimes Against Property. Our sources for this module are our textbook, Criminal Law for Criminal Justice Professionals, as well as Louisiana Revised Statutes, Title 14, Chapter 1. Our learning objectives for this module are to explain the crime of arson and the evolution of its definition from the common law to what we have now in the modern law, list the elements of the crime of burglary, define the crimes that constitute theft, list the elements of the crime of embezzlement, and then contrast the concepts of extortion, blackmail, and bribery. Our first crime that we'll discuss is crimes against habitation, known as arson. The common law development of arson was intended to provide a security blanket and a protection to a person's dwelling. Within the common law definition, arson had a malicious intent, which is a desire to injure by means of a crime, and that the act be willful, that it's done intentionally. And in the crime of arson, of course, this willfulness is the burning of another's home. In the common law, the house was defined as the dwelling of the occupant and any other buildings immediately surrounding or associated with the home, which is known as the curtilage. This includes things like the barn, an outhouse, a milk house for milking cows, or any other exterior ancillary buildings. The burning under the common law, the burning of an unoccupied house or dwelling didn't constitute arson. The building had to be occupied. And in terms of what constituted arson as well, charring of the wood had to occur. Modern law, however, considers arson to be violent and a crime against habitation and the property itself. The definition of arson, the common and general definition of arson, is the malicious, willful burning or attempted burning of one's own or another person's property. In terms of the Model Penal Code, the definition for arson it includes that a person is guilty of arson if he or she starts a fire or causes an explosion with the purpose, with the intent of destroying a building or occupied structure of another, or destroying or damaging any property, whether his own or another's, to collect insurance for the loss. Most state statutes define property as almost any structure or personal property, and when we talk about structure, we mean including those that are not used as a place to sleep. Arson is a general intent crime in most instances. That is, only the intent to burn is required. And arson has several elements and degrees. Most states have varying levels of degrees of arson depending on the elements of the crime that are present, including was the actor, the level of recklessness of the actor, any aggravating circumstances, what type of property is burned, any previous convictions for arson of the defendant. The value of the loss could also change the degree of arson, and the presence of any people in the building or buildings that are burned. Another crime of habitation is burglary. The common law viewed burglary as a serious felony punishable by death. It was a forcible invasion and a disturbance of a person's right to habitation. The definition within the common law was the breaking and entering in the nighttime of the mansion or dwelling house or curtilage of another with the intent to commit a felony. Modern law, however, has expanded the scope and definition of the crime is it being an offense committed by entry alone, whether it be day or night, in any building, structure, or vehicle with the intent to commit any criminal offense. The modern penal code defines burglary as the entry of a building or occupied structure or separately secured or occupied portion thereof with the purpose to commit a crime, unless the premises are at the time open to the public or if the actor is licensed or privileged to enter. There are three elements to the crime of burglary. First, you have to have an entry. And this entry could be no matter how slight. An entry is the forcing open of a door or a window, which is breaking and entering, entering through a partially open door or window, or entering through a closed door. This could be during day or nighttime hours. However, a burglary at night may influence the degree in some states. There's no requirement of physical entry. It may be done by constructive entries. For example, an instrumentality is used, like a person, an animal, or an object. Consent can be a valid defense in states where the breaking element is required. The second element of burglary is that it be of a dwelling or a building. In some states, occupancy may make a difference in the actual crime that's charged. And generally, the sleep test is applied. Whether a person is actually in the building or structure or not, if the dwelling is used regularly to sleep in, is considered to be an inhabited dwelling. And the third element is with the intent to commit a crime inside. Removal or touching an item is not required, but if the intent is formed after entry or no intent is present at all, then there's no burglary. It might be considered a theft or trespassing at that point. In terms of breaking and entering, the definition of that particular facet of the crime is that it is an unlawful forced entry. This is when a person lacks intent to commit a theft or felony inside the structure. You might have this in a situation where a person enters a building to squat there or be a vagrant inside of a building. They've committed a burglary, but there's no intent to commit a theft or other felony. In terms of degrees of burglary, most states have a simple burglary statute or even an aggravated burglary statute in which the burglary is committed when the offender is armed with a dangerous weapon. Some states have first or second or even third degree burglary crimes in their statutes. Possession of burglars tools is the possession of tools and instruments that are designed, adapted, and commonly used to commit burglaries. The tools and the instrumentalities, along with the intent to use the tools and commission of a burglary, constitute the elements of the crime of possession of burglars tools. It's important to note that this is a separate crime from burglary, but not an element. So you can be charged and have an element of a crime or burglary that was committed and the burglar not be in possession of burglars tools, and then vice versa. The intent of this crime of possession of burglars tools is general, meaning the prosecutor has to prove the intent to commit some burglary, not just a specific burglary. Crimes against property include the crime of theft, and there's many forms and variations of the crime of theft. The first form is what's known as larceny, and there are four elements of the crime of larceny. Number one being the taking and carrying away, in which the thief exercises some control over the property and moves it even slightly for at least a brief time. The second element of larceny is that that it be the property of another person. The property must be tangible, it must have value, and it must have an owner that can positively identify the property as hers or his through some type of marking, some type of serial number, or other way to identify the property. The third element of larceny is that it occurred without consent. This is usually done through testimony or direct evidence, but it also can be through the length of time the defendant possessed the property or make any efforts to remove the marking, which constitutes circumstantial evidence of the crime of theft. And then the fourth element of larceny is with the purpose of stealing or permanently depriving the owner of possession of the property. There are varying degrees among states for the crime of larceny, and this is generally by value of the property, whether it was stolen directly from a person or shoplifting, etc. Larceny from a person includes crimes like pickpocketing, purse snatching, where there's no fear or force is used. If fear or force is used, of course, that constitutes another more violent crime. Shoplifting is the theft of merchandise, concealment of merchandise, altering a price tag, and any other type of retail theft. And elements of shoplifting include the willful taking of or possession of merchandise of another without consent of the seller and with intention of converting goods or without paying for the goods. Another avenue of larceny is the possession of lost or abandoned property. The object becomes abandoned when the person who owns it voluntarily gives up possession or ownership of it. However, the finder must give the object back under three conditions: that the owner can be identified, the item can be easily given back to the owner, and the item has substantial value. Borrowing an item with intent to return it to the owner, even without permission, is not considered larceny. For example, joyriding is a common theme of borrowing an item with intent to return it. Taking a car without permission and driving it for a short amount of time is what we know as joyriding. However, some states have unauthorized use of motor vehicle statutes that cover situations where an owner gave consent to the user, but the vehicle was kept beyond this length or this span of consent. A second type of theft crime is what's known as embezzlement. And there are two elements to embezzlement. It is the misappropriation, number one, of the property of another, number two. Misappropriation is the wrongful misuse or taking of another's property, while the property of another includes anything that's real or personal. It includes securities, other types of negotiable instruments, pay drafts, checks, certificates of deposits, and in which these financial instruments, negotiable instruments, have been entrusted to the person that conducts the embezzlement. Embezzlement crimes have been statutorily created to address situations when people, typically employees, who lawfully come into possession of property as part of their job duties, and then they take it for their own use. Another type of larceny is theft by false pretenses. This is when the owner is tricked by some type of misrepresentation into voluntarily transferring a title to certain property. This type of law was statutorily created to address shortcomings in the common law when dealing with larceny. There's three elements of theft by false pretenses, including the making of a material misrepresentation of fact with the intent to defraud the owner of the property, and thereby inducing the owner to part with both possession and title to the property. The fourth a type of theft is receiving stolen property. Theft is not an element of receiving stolen goods, and the prosecution doesn't have to prove that the defendant stole the goods, his or herself. Receiving the stolen goods means to acquire the goods or property that has been stolen. Three elements of the crime include the accused bought, received, or otherwise came into possession of the property that was stolen. The property was in fact stolen, and at the time of the possession of the property, the accused knew the property had been stolen. In terms of receiving stolen property, the physical control of the goods is not a requirement. Only constructive possession is required. There must be a relationship between the defendant who is charged with the crime and the stolen goods, and that it's reasonable to treat the extent of the defendant's control of the goods as if it were in their actual possession. So this means that if it's in close proximity or they use it on a regular basis. Other crimes against property include extortion, blackmail, and bribery. Under the common law, extortion was defined as the gaining of property by threat of physical harm to a person or property by a public official under the color of his or her office. Within the common law, there were some elements to extortion to include seeking an unlawful fee by a public officer collected under the color of office, where the fee is actually received and where the fee was taken corruptly. These common law elements have generally been maintained in the modern law with some revisions to include that the property be tangible and intangible, that there be some type of threat of harm in the future, a threat to expose a victim's involvement in some type of crime or other shameful acts. And generally, extortion is done for monetary gain or some type of action that benefits the actors involved. In terms of blackmail, blackmail is defined as the threat by a private citizen seeking payment to remain silent about a crime or a shameful act that's been committed. This is considered extortion in some states, but there's this paradox within the crime of blackmail. The crime involves an act or acts that the perpetrator has a legal right to tell somebody about. But in terms of what constitutes a crime is that the actor, the defendant, seeks something in return for keeping quiet. In terms of bribery, the definition is the payment by a person to a public official in order to gain an advantage that the person is not otherwise entitled to. Both parties, both the giver and the receiver, have committed the crime of bribery when a payment is made. You generally see this, of course, within the political realm, also in the law enforcement and criminal justice system as well. Forgery is when, for the purpose of deceiving or injuring another, a person makes or alters some type of written document in such a way as to convey a false impression that the document is authentic. For example, when a person signs a name other than his or hers and claims that the signature belongs to the other person, signing with a fictitious or assumed name, falsely signing some charge slip, a sales slip, or a money order, using tricks, artifices, or devices to procure a genuine signature. So an example would be using computer software to generate a fictitious document. The mere possession of forged writing doesn't constitute the crime of forgery until the writing is presented or it's attempted, its use is attempted. And this is what's known as being uttered. The writing is uttered when it is presented and the person attempts to use it. The intent required within forgery is to defraud. And the mere fact that the fraud or the forgery wasn't completed doesn't necessarily mean that the crime can't be prosecuted. You can still prove intent even though the act wasn't completed. So in this module, we talked about the crime of arson and the evolution of the crime of arson from the common law through to the modern law. We listed the elements of the crime of burglary, defined the crimes that constitute theft. We listed the elements of the crime of embezzlement, and then we talked about the difference between the concepts of extortion, blackmail, and bribery.